In the domestic case of Balfour and Balfour, a husband had to leave England for work, but because his wife could not accompany him due to her illness, the husband orally promised to pay the wife £30 a month before he left for the maintenance of the household and the children when he was gone. Over time, however, they drifted apart, so the wife sued the husband to keep up with his promise to pay her monthly. The court unanimously denied the wife's claim, but each of the three Lord Justices in the Court of Appeal used slightly different language. Lord Justice Warrington's speech used language similar to a consideration. He stated that if we were to hold that there was a contract in this case, we should have to hold that with regards to all the more or less trivial concerns of life, whenever a wife at the request of her husband makes a promise to him, that is a promise which can be enforced in law. All I can say is that there is no such contract here. These two people never intended to make a bargain which could be enforced in law. The husband expressed his intention to make the payment, and he promised to make it, and was bound in honor, not by law, to continue it. The wife, on the other hand, made no bargain at all. That is, in my opinion, sufficient to dispose of the case. So we can see here that part of Lord Justice Warrington's reasoning is because the wife did not give any consideration for the payment. Lord Justice Duke, however, used language which seemed to demand more than consideration, such that even if it was accepted that consideration had passed between the parties, something additional was necessary. Here, Lord Justice Duke also gave emphasis to the fact that the parties in this case had not yet divorced and were still husband and wife. He said that an agreement for separation between a husband and wife does involve mutual considerations, but in this case, there was no separation agreement at all. The parties were husband and wife, and subject to all the conditions in point of law involved in that relationship. In order to establish a contract, there ought to be something more than mere mutual promises having regard to the domestic relations of the parties. The proposition that the mutual promises made in the ordinary domestic relationship of husband and wife of necessity give cause for action on a contract seems to me to go to the very root of that relationship and to be a possible and fruitful source of dissension and quarreling. Finally, Lord Justice Atkin's speech is where we can see most clearly a discussion on a bespoke intention to create legal relations requirement. His lordship held that an ordinary example is where two parties agree to take a walk together, or where there is an offer and an acceptance of hospitality. Nobody would suggest in ordinary circumstances that those agreements result in what we know as a contract, and one of the most usual forms of such agreements appears to me to be the arrangements which are made between husband and wife. It constantly happens that such arrangements made between husband and wife are arrangements in which there are mutual promises, or in other words, in which there is consideration. Nevertheless, they are not contracts, and this is because the parties did not intend that they should be attended by legal consequences. They are not sued upon, not because the parties are reluctant to enforce their rights, but because the parties, in the inception of the arrangement, never intended that they should be sued upon in the first place. Agreements such as these are outside the realm of contracts altogether. The common law does not regulate the form of agreements between spouses.